Good afternoon. My name is Marilyn Edge, Acting Director of the Office of Asset Management and Portfolio Oversight. Welcome to Multifamily Housing's first of two training broadcasts on requirements of HUD's final rule implementing the 2013 Violence Against Women Act. The webcast today will cover VAWA final rule from an owner-ager perspective. The second webcast will be on Tuesday, August 1st from 1:30 to 3 o'clock p.m. Eastern Time, and that webcast will cover VAWA final rule from HUD PBCA perspective. Sitting next to me are our presenters for the training, Danielle Garcia and Anicia Dorr. Carissa Janis is also with us today. She is in the studio fielding the live questions that you can submit during the presentation. The VAWA final rule was published in November 2016, and we published Housing Notice 2017-05 on June 30th. Both our final rule and notice are critical steps in providing protecting affordable housing opportunities for people experiencing domestic violence, dating violence, sexual assault, and stalking. The final rule and changes to VAWA are significant for multifamily housing. The requirements now apply to all assisted housing properties, including Section 202 and 811 PRACs. Some of the major components of the VAWA rule include continuation of the core protections. The rule extends the core protections across HUD's covered programs, ensuring survivors are not denied assistance as an applicant or evicted or have assistance terminated due to having been a victim. Emergency transfers. One of the key elements of VAWA's housing protections is the requirement for housing owners to develop emergency transfer plans. These plans describe each property's emergency transfer policies that will help survivors move to another safe and available unit if they fear for their life and safety. Protections against the adverse effects of abuse. Housing owners cannot deny tenancy based solely on adverse factors that are a direct result of being a victim. Low barrier and flexible certification process. Survivors may self-certify or choose the type of third-party documentation to provide in order to exercise their rights under VAWA. Thank you for joining us, and we hope you find this training helpful as you implement the VAWA final rule at your property. Now we'll turn it over to Danielle, who will cover the agenda for today. Danielle?
Yep, thank you, Marilyn. I am excited to be here today and provide the training on a topic that we worked long and hard to get out the building. Right now I'm going to cover the agenda, and Anicia will cover the first half of the training. Her topics will include purpose and background, applicability, protections and eligibility, notification that you as an owner have to provide to your residents, and documentation that may be requested of an applicant or tenant requesting VAWA protections. The latter part of the presentation I will cover, and my topics will include what to do for a lease bifurcation, what actual and imminent threat means. I'll discuss the requirements of the emergency transfer plan and how HUD will enforce the VAWA final rule. So next we will kick it off to Anicia.
Thank you, Danielle. And I agree with Danielle. We're very excited about getting this notice out the door, and we worked long and hard on it. And since the publication of the final rule in November of 2016, there has been multiple industry meetings and presentations. And some of us here at HUD headquarters have actually gotten a chance to participate and listen in on those discussions and webinars. And we've gotten some really good feedback, and what we tried to do was incorporate some of the feedback as well as some of the questions and concerns within this notice. So we'll kick it off and just start off with just a brief summarization of some of the changes that the final rule brought about. Previously, sexual assault was not considered a VAWA covered crime, but with the final rule, sexual assault is now considered a VAWA crime. The final rule also implicates new requirements for the Notice of Occupancy Rights, which is Form 5380, and I'll be going over that form in more detail here briefly. The final rule also implicates that applicants and tenants may not be denied assistance or have assistance terminated on the basis of or as a direct result of having been a victim of domestic violence, dating violence, sexual assault, or stalking. And the final rule also established requirements for creating an emergency transfer plan and for related record keeping and reporting. And we've gotten a lot of feedback from the audience regarding the emergency transfer plan, and Danielle will be going over the emergency transfer plan a little bit later in the presentation. The final rule also, it revised requirements for documenting the occurrence of VAWA crimes, and that caused us to update one of the existing forms. I believe it was the 91066. That is actually now Form 5382, and I'll be going over that in a little bit more detail here shortly. It also establishes reasonable time periods for a tenant who is a VAWA victim to remain in the unit while establishing eligibility or seeking alternate housing after a lease bifurcation. The final rule also clarifies the owners may establish preferences for victims of those VAWA crimes. The final rule, it also implements some new forms, which it caused us to update some, create new forms as well as update some old forms. The first form is the Notice of Occupancy Rights, and which is actually Form 5380. And then actually the next form is the Model Emergency Transfer Form, which is 5381, and as I said, Danielle will be going over that, the contents of that here shortly. The Certification of Domestic Violence, which is 5382, and I'll be going over that one as well, and that form is actually provided in conjunction with the 5380. The Emergency Transfer Request for certain victims of domestic violence, dating violence, sexual assault, and stalking. That is Form 5380. And forthcoming, we are updating the 91067, which is the VAWA lease addendum. And we have, and all of those forms are actually posted on the HUD HUD clips. However, those forms that are posted on HUD clips, they are expired, but we strongly encourage that you guys continue to use those forms until new forms are provided. We've actually gone through the process of updating them, and they've actually, we received an email a couple of days ago just saying that that those forms have been cleared for publication in the Federal Register, and will they be posted for comments for 60 days. And so you guys keep an eye out for that, and they should be posted within the next week or so. And just make sure that you provide your comments, and then after the 60-day comment period, we will respond, we'll go through and respond to all the comments, and there'll be the forms be posted again for an additional 30 days, so you can actually see the comments that we, the responses to the comments that you made. Overall, it looks like it'll probably be maybe like 5 or 6 months or so before the forms are actually available to you guys. But as I said, just continue to use those forms that are posted right now until the new forms are available to you. And now we're going to talk about the purpose and a little bit of background on the notice here. The notice, basically the purpose of the notice is provide guidance on how to implement the VAWA final rule. It is, the notice does not include all of the components of the final rule, so that it should be used in conjunction with the final rule. It supersedes, this notice supersedes HUD Notice 2013-23 as well as HUD Notice 2009-15. And a little bit of background, final rule was actually published in November 2016, and most of the requirements were actually implemented December 2016. The emergency transfer plan portion of it, the requirement of it was actually implemented June 14th of this year, which was just last month. And you can go, there's additional information on the background of the, that can be found in Section 1 of the preamble of the final rule. Okay. Now, what programs is this applicable to? It's actually formally previously, some programs were not required to provide VAWA protections, but since the final rule, now all the assisted multifamily housing programs are required to provide VAWA protections. It applied to family properties, elderly projects, even disabled projects as well, which includes your project-based Section 8, your PACs, your PRACs, your SPRACs, 236, the 811 PRAs, the 221 D3 and D5. So in the grand scheme of things, you might ask, what is the final rule all about? Basically, the VAWA final rule is it provides VAWA protections, and HUD housing programs may not deny or terminate applicant tenant assistance or tenancy on the basis or as a direct result of the applicant or tenant currently or having been a victim of domestic violence, dating violence, sexual assault, or stalking, and if the applicant or tenant otherwise qualifies for admission, assistance, participation, or occupancy. So who's eligible for VAWA protections? Applicants and tenants of HUD housing programs who are victims of domestic violence, dating violence, sexual assault, and stalking. They're the ones that are actually eligible to receive these protections. Despite the acronym VAWA, which stands for Violence Against Women Act, there's no limitation to just women, and it's available to everyone without regard to sex, without regard to sex, gender identity, or sexual orientation. So who does this not require? Who does this not apply to? It does not apply to guests, unassisted households, live-in aides are not eligible for protections limited to tenants. However, as a reasonable accommodation, a tenant can request protection if a live-in aide or a victim a tenant can request a reasonable accommodations if a live-in aide is a victim of domestic violence or of a VAWA crime, and the tenant can request an emergency transfer in that case. For example, if Mark, who is a live-in aide for tenant Jonathan, who is the head of household, Mark has an ex-partner who has stalked him, and he's actually become a victim of a VAWA crime. Jonathan, the head of household, can then request VAWA protections based on the grounds that Mark is a live-in aide and he needs him for assistance, and he can then therefore qualify for VAWA protections and request to be moved to another unit. Okay.
Great, thanks, Anicia. So just a reminder that we are taking live questions today. And if you do have questions, please send them over to Carissa L. Janis, CARISSA period L period Janis, JANIS at HUD.gov. And Carissa will be joining us at the end of the presentation, helping answer the live questions. Currently, she's fielding out which questions we're going to be presenting later today. So we do have one question here that came in. A guest of a tenant of a covered property was sexually assaulted at the property. Can the guest request emergency transfer for VAWA Protections? Anicia, what do you think?
No, applicants are not eligible for emergency transfers. However, an owner may adopt admission preferences for applicants who are victims of domestic violence, dating violence, sexual assault, or stalking. Without that preference, the applicant would be placed at the end of the wait list.
Okay. And let's take a minute here. Let's see. Okay, one more question came in. Does a tenant qualify for VAWA Protections if the abuse did not occur on the property? So it sounds like physically on the property.
Yes,
okay.
Exactly, yeah. If the tenant does not feel safe or determines that that there might be an imminent danger by them remaining on the property, they do qualify for VAWA Protections.
Okay. And let's see here, last question. It looks like, can VAWA final rule regulations be applied to all subsidy types to include LIHTC, which is your tax credits? What do you think?
Well, the final rule, it only applies to applicants and tenants of covered housing programs. Owners may choose to extend those VAWA protections and remedies to other tenants. However, properties with tax credit units should seek guidance from the Department of Treasury or the appropriate HFA for guidance or implementing VAWA on that property.
Yeah, I agree. And that is a question that has come in quite frequently. And HUD can only implement policy at our HUD-assisted units, so we're advising y'all to get with IRS, Department of Treasury, of how they want to treat their tax credit units. So I would suggest keep sending in your questions over to Carissa L. Janis, and we will have a few more breaks throughout different topics and a larger portion at the end also.
Okay, now we'll get started in the notification section. The final rule requires that HUD created a notice that actually describes what the VAWA rights are, which is where the 5380 comes into play, the notice of occupancy rights. In this form, it must be used without changing its core protections or confidentiality rights. However, it must be customized to reflect the specific assistance provided under the covered housing program. For instance, it can include the company's name, the organization, the property name, any other additional information or terminology that is used in the program and makes the VAWA notice of occupancy rights more meaningful to applicants for tenants. And then also the form, the Notice for Occupancy Rights 5380, it must be distributed in conjunction with the 5382, which is the certification form. And they must be submitted, they must be provided to the tenant or applicant at the time of denial of assistance. So when an applicant is rejected, those two forms have to be provided to them. It must be provided at move-in to all move-ins, new move-ins. They have to be provided as well to the along with the notice of eviction and termination of assistance. And through December 2015, December 15, 2017, each household during its annual certification, they must receive those forms as well. And if the annual certification has already passed, the household has already passed, Those forms must be provided through other means no later than December 15, 2017. And just one thing I did want to note is that the VAWA final rule does not require that applicants or households sign an acknowledgement of the receipt of the notice of occupancy or the certification form. But we strongly encourage that owners and agents, they maintain a note or other documentation in each tenant file that indicates when each applicant or household was provided those forms.
Anicia, can property managers change the form?
They can change the form, but they cannot, as I stated, they cannot change the core protections of the form as well as the confidentiality rights.
Okay.
Those cannot be, those have to be maintained.
Great.
Okay. The notification, as I said, it has to be provided with each notification of termination or eviction, whether the eviction be for, whether the notice be, the eviction be for material noncompliance or criminal activity, or if termination of assistance be because of the failure to respond to recertification, failure to move to a different size unit, increase in income where the tenant's income has actually exceeded the subsidy, and so they no longer qualify to receive subsidy. Those two forms have to be provided to the tenants at that time.
So this is a question we do get a lot. So with those two forms, does it need to be provided at every occurrence? So you know when you're proceeding with eviction, you send multiple notices to the family. At what point do you recommend sending these two forms to notify the family of their VAWA rights?
Okay, I'm glad you asked that.
Oh, great.
Actually, I was going to get into that. And actually, those you would provide those forms with the initial notice. And it is, the forms are actually provided per event, per, how can
Action.
I put it? Per action, yes, that's a good way to put it, per action. So if I issue a termination notice because the income exceeded the income limits, then I would send those forms for that. But the same household, if later on I sent them an eviction notice, then they would those forms we have to be provided again for that as well. Okay.
Thanks.
But I do want to remind you just to ensure that you refer to the HUD Handbook 4350, and that's Chapter 8, the termination chapter, just to make sure that you are in compliance with other eviction and termination requirements. And now let's speak about the lease addendum. We are in the process, well, actually we've revised the VAWA lease addendum, the HUD Form 91067, and we revised it to include some of the provisions that are included in the final rule. And that is going to apply to all multifamily housing programs. They provided, and they're actually going to provide those to the current household at their next annual recertification. They also must be provided at move-ins for new move-ins as well. But just keep in mind that in issuing these forms with an annual recertification, that you're actually modifying the lease, and the tenant has to be given a 60-day notice for lease modifications. And you want to refer to HUD Handbook 4350, and I believe that is paragraph 6-12 on the notification procedures, the requirements, rather, that you have to follow on that. And as I said, HUD, we have updated those forms. However, the forms that
We're in the process of updating.
yeah, in the process.
Yes.
Yes, clarify that. We're actually in the process of updating those forms, and the the current lease addendum, it does not include the PRACs, the 202 and 811 PRACs, and so the new updated forms are gonna include those. And so if those particular properties, if they want to wait to implement the VAWA lease addendum, they are more than welcome to do so before actually implementing them on site. Okay, now say documentation. It's very important that all things are documented properly and are readily available when someone needs to see that. So you want to create a paper trail or a note trail to show what your actions are. And in doing that, you want to make sure that you create policy that you're actually going to follow. And so, because the owner, they may accept verbal requests, but however they decide, however you guys decide that you want to accept the VAWA request, you need to just make sure that you follow those, follow whatever you say you're doing. And then also, the owner may require written certification or other documentation. And the owner can request written certification, but if they do request, so if you do request written certification, it must be in the form of a written and dated letter. And it's an important reason for that, and I'll touch on that here briefly. So simply just providing the forms, if somebody come in and say they want to request VAWA Protections, just simply providing the notification and the certification, that's not asking them for additional information. It needs to be in the form of a written letter, dated letter, okay? Now the certification form, which is Form 5382, actually, that, as I stated before, that form is previously Form 91066, and 91066 is now obsolete. So if you guys are using that particular form, discontinue use and switch over to the 5382. And the 5382, it provides several things, and just a few is it provides a list of acceptable forms of third-party documentation to satisfy the request of documentation. It explains the time for responding to written requests for documentation, and it describes the confidentiality protections under the VAWA rule. And there are other things that it does that the form actually includes, so I strongly suggest that that you read over that form at your leisure. And as I stated before, this form must be provided along with the Notice of Occupancy Right, which is 5380. And it must be, the owners must accept this certification form or other documentation to validate the victim status. There are some other permissible forms that are allowed, that can be accepted. A signed documentation from a professional, from a professional which sought the victim sought assistance. The victim sought assistance from. Also, a record from the government or law enforcement or administrative agency or court. At the owner's discretion, there can be other forms of evidence requested, but that needs to be, the owners are encouraged to develop written policy whether they will exercise that discretion and accept other forms of evidence. Owner cannot require more than one type of documentation. For example, the Form 5382, it may be accepted in lieu of other permissible documentation. And as I stated, that it's important that additional information that you might need from the tenant, that it be in a written form. That is very important because there are response times that the final rule sets forth, and the owner may require that the tenant respond within 15 business days, and that's after the date the individual receives the written request of documentation. The owner, at the owner's discretion, this time period may be extended, and during that 14-day period, as well as any granted extensions, no adverse actions such as eviction, termination can be taken against the individual requesting VAWA protections. If documentation is not submitted on time, nothing in the final rule limits the owner's authority to evict or deny assistance or terminate assistance. And just keep in mind, if a VAWA protection is denied, that the owner agent must follow established grievance procedures. And with all the documentation, it's very, very important to maintain them in a confidential manner. And so the final rule, it did speak strongly about confidentiality, and it's quite a large section in the notice as well, discussing victim confidentiality. All information and documentation must be maintained with strict confidentiality. The VAWA information not provided. It shouldn't be provided to employees or contractors unless the law requires. And it shouldn't be entered into a shared database or provided to others without the consent of the victim, or unless required for an eviction action or by law. And the owner agent should secure all correspondence and personal interactions with the victim to maintain confidentiality. And just keep in mind that those VAWA correspondence, it must be maintained in a secure place that's separate from the tenant's file. And a little bit more on victim confidentiality. Owners, they should document in the tenant files the preferred method of communication. So owners should ask the victim what their preferred method of communication is, whether it be an alternate number or an email, just in case that the abuser may have access to the phone number or other normal means of communication that you might have with that tenant. So just make sure that you communicate and document if there is if the victim does want an alternate method of communication, a preferred method of communication. Victims may designate an attorney, an advocate, or other secure contact for communications, and that must be documented as well. And as I said, the VAWA communication must be separate from the tenant file. And the program, the notice does have lists several things that are best practices. For example, they can conduct intake sessions in a private room where the individual and staff persons can talk without the risk of other staff or clients overhearing them. Communicate to the individual, whether property management staff or whichever person is responsible for handling those questions or complaints about confidentiality. Ensure relatives staff understand the confidentiality policies and procedures through regular staff training, and post notices about the importance of maintaining confidentiality throughout the office, and clarify information sharing policies with referring and referral agencies and other services and businesses and partners. Okay, so now we're going to talk a little bit about adverse actions.
Adverse factors.
I'm sorry, adverse factors. Yes, adverse factors. Yeah, the final rule, it prohibits owners and agents from denying admission or assistance or terminate assistance or evicting based on an adverse factor that is determined to be a the result of the fact that the applicant or tenant is or has been a victim of a VAWA crime. The applicant or tenant must inform the owner or agent that he or she is actually a victim for them to be able to, and then they also must provide the required documentation for them to make that determination regarding any adverse factors. The owner agent may ask for clarification. If you need more clarification, then you're more than free to do so for clarification or either additional information. The owners may consider documentation of adverse factors resulting from being a victim of the victim that otherwise deems the individual ineligible. On the surface, adverse factors may appear to be unrelated to being a victim. However, the owner agent must make a reasonable determination whether the adverse factor is a direct result of an applicant or tenant being a victim of having been a victim. And some of the examples of adverse factors might be poor credit history, which the poor credit history that resulting from the abuser's use of the victim's credit card or debit card or running up debt on joint accounts. Poor rental history resulting from early lease terminations or short lease terms. Criminal record resulting from the victim being forced to write bad checks or misuse credit or even file fraudulent tax returns. Failure to pay rent resulting from abuser preventing the victim from obtaining and or maintaining employment. And the notice does include other adverse factors that might be considered as well. And so now we are going to do a case study. Yay! And so, okay. Sean applied for assistance at a project-based Section 8 property and was notified by the owner that the application was denied due to a poor rental history, as he was previously evicted 2 times. Sean informed the owner that the eviction stemmed from criminal activity engaged in by an abusive partner that is no longer a household member, and provided documentation to support that claim. So how should the owner proceed? So what do you think, Danielle?
Well, I'm going to look for the answer on the next slide. And but this is a real life scenario that can happen. What we're providing is that Sean provided documentation supporting the claim that their poor credit history was a direct result of being a victim of domestic violence. So in that situation, the owner agent must not just deny admission based on the adverse factor. The main part is given the opportunity for that applicant to show that they are requesting VAWA protections, and then at that point you would want to admit them into your household.
Yes. So overall, Sean provided the necessary documentation that supported his claim, and therefore he shouldn't be denied admission. But if a denial or termination of assistance or eviction is required by a federal statute based on a particular adverse factor, the owner must comply with that statute even if the adverse factor is a direct result of a VAWA crime. For example, if an applicant is subject to a lifetime registration requirement under the state sex offender registration, then that applicant must be denied.
Okay, good point, thanks. And just a reminder, everybody, please continue to submit your questions to Carissa.L.Janice@HUD.gov.
Okay. Conflicting evidence. There may be times when you as an owner agent may receive conflicting evidence where more than one party they're both claiming to be a victim of domestic of our crime. And in that case, the owner can request additional documentation from both parties at that time. The requested documentation, okay. And then there might be a case where the requested documentation that you receive may contradict initial information that was previously provided. In that case, there may be the time may be extended to 30 days.
Okay.
And owners and agents review all documentation submitted and make a decision regarding the VAWA protection. So after all the documentation is submitted, the owner is going to make that determination from that point. And when evicting a household member, just make sure that the outstanding grievance procedures and family breakup policies are followed. And actually, and I believe the next session that you're actually covering, Danielle, is going to be on lease bifurcation, and which is another really, really hot topic. We received a lot of feedback from regarding that as well. And so now we're open to more questions.
All right, so let's take a few more questions. First question, can an owner agent require victims to provide a specific document as evidence for VAWA claims?
No. If an owner agent requires documentation to support VAWA claims, the applicant or tenant may satisfy this requirement by providing any of the documents as described under the Code of Federal Regulations, and that is 5.2007B1, I believe it is. And note that the VAWA final rule does not require owner agents to obtain written documentation on victim status. Written policies should describe under what circumstances a verbal statement will be accepted.
Okay. And I believe this, you covered this one before, but are 202 PROC and 811 PROC properties required to use current VAWA lease addendum form 91067?
And as I stated, HUD is in the process of updating the VAWA lease addendum, which is the 91067, to include the 202 and 811 PRAC properties. Therefore, those properties they are more than welcome to wait to implement the VAWA lease addendum until the form is updated and issued by HUD. Thank you, Danielle.
All right, so I am up. Thank you, Anicia. Well, thank you, everybody. So next topic will be lease bifurcation. And let's see here. The occurrence of domestic violence, dating violence, sexual assault, and stalking may lead to a breakup of the assisted family. A family breakup involves terminating the assistance of the perpetrator while continuing assistance to the victim. And in Notice 17-05, quote-unquote bifurcate means to divide a lease so that certain tenants can be evicted or removed and the remaining tenants or lawful occupants can continue to reside in the unit under the same lease requirements. Essentially, the perpetrator is taken off the lease and the new lease is executed with the victim and other household members. Lease bifurcation does not apply to guests, unreported household members, or anyone who is not a tenant. Next slide. This slide's good. And then, eviction, removal, termination of occupancy rights, or termination of assistance must be in accordance with federal, state, or local law for termination of leases. For example, some jurisdictions may prohibit partial or single tenant evictions. And in order to avoid unnecessary delay in the bifurcation process, we at HUD recommend that owner agents seek court-ordered eviction of the perpetrator pursuant to applicable laws. This process results in underlying lease becoming null and void once the owner agent regains possession of the unit. The OA would then execute the new lease with the victim. HUD also encourages owners' agents to simultaneously attempt to reach an agreement to the mutual termination of the lease if it is safe to do so. Remember that removing a household member from the lease is also changing the family composition, so you may require the victim to move to another unit of the appropriate size. But at the end of the day, you should follow your occupancy standards in your tenant selection plan when determining the appropriate sized unit. Thank you. And still on lease bifurcation, the final rule establishes a reasonable time period for remaining family members to demonstrate eligibility for housing assistance or find alternative housing following lease bifurcation. Remember that the remaining family member has to meet statutory requirements for housing assistance. Examples could be looking at immigration status, age, disability status. And in most cases, the owner agent must provide the family member a period of 90 calendar days from the date of lease bifurcation. However, here's a few examples where there might be exceptions. So for your 202 and 811 pracs, you're going to give 90 calendar days or whenever the lease expires, whichever is first, to check to see the age and disability criteria. For your Section 202/8, Section 8, and Section 236s, whenever it comes to immigration status, you're able statutorily to provide 30 calendar days. And this period will not apply beyond the expiration of the lease unless permitted by program regulations. And this slide is comes from the preamble, the final rule, and also the housing notice. It shows the statutory limitations that may prevent remaining tenant from establishing eligibility. So it's a good quick reference chart to kind of give you an idea of where the regulatory citation is and the reasonable amount of time that a victim can remain in the unit. So the next slide, we have another case study for y'all. And Nisa, you want to read it?
Sure. Say Susan, who is 64 years old, and Jason, who is 58 years old, are a household and live in a Section 202 elderly property. Susan, who is the head of household and program qualifying household member, has no income and receives an elderly deduction. After an altercation, Jason claims VAWA Protections. On September 15th, Susan moves out of the unit and leaves Jason as the sole household member. Jason's rent increases because the household no longer receives the elder deduction. Can Jason remain in the unit and become the head of household?
Alrighty, thanks. So we broke down the answer of what you would do for your 202/8s and 202 pracs. And at the end of the day, we want you to also follow guidance in HUD Handbook 4350.3, paragraph 3-16. So if the individual who establishes eligibility for the project leaves the unit for any reason other than death, the owner must determine if the individual still residing in the unit meets eligibility requirements for the project. So for your 202s with project-based Section 8, Jason must meet program eligibility requirement within 90 days or whenever the lease expires, whichever comes first. If eligibility cannot be established, the individual may remain in the unit but must pay the contract rent. For your Section 202 pracs, since Jason is 58, he does not meet program eligibility requirements. He must vacate the unit within the 90 days or whenever the lease expires. And if he stays within that 90 days, he must pay the operating rent for that property. Big picture is that your section 228s and 22, also in line with your 202 pracs, the individual may remain in the unit but must pay contract rent, while your 202 and 811 pracs, the individual may not remain in the unit and must pay operating rent. All right, so next we will discuss actual and imminent threat of the VAWA final rule. So the VAWA final rule prohibits denial and admission, termination of assistance, or eviction on the basis or as a direct result of the fact that the applicant or tenant is or has been a victim of domestic violence, dating violence, sexual assault, or stalking. However, nothing in the final rule may be read to limit authority of the owner agent to terminate assistance or evict a tenant if the owner agent can demonstrate that an actual and imminent threat to other tenants or those employed at or providing services to the property would be present if the tenant or lawful occupant is not evicted or terminated from assistance. And in order to demonstrate an actual and imminent threat to other tenants and employees of the property, the owner agent must have objective evidence of words, gestures, actions, or other indicators of such threats. In determining whether an individual would pose an actual or imminent threat, the factors to be considered include the duration of the risk, the nature and severity of potential harm, the likelihood that potential harm would occur, and the length of time before the potential harm would occur. Now, an eviction or termination of assistance should only be used by an owner agent when there are no other actions or remedies to reduce or eliminate the threat, including when actions and remedies are unavailable. Owner agents may evict a victim or terminate assistance if they can demonstrate that an actual and imminent threat to other tenants or those employed at or providing services to the property would be present if that tenant or lawful occupant is not evicted. So here we have another case study for you. Lacey, would you mind reading?
Sure.
Thanks.
In response to a lease infraction for repeated disturbances, Samantha, a resident of ABC Properties, informed the property manager that she was a victim of domestic abuse. As a result, the manager barred the abuser from the property and offered Samantha an internal transfer. Although she claimed VAWA Protections, Samantha refuses to follow through with other resources included in the property's emergency transfer plan and maintains a relationship with the abusers. The couple's repeated altercations disrupt other tenants and causes them to fear for their safety. So Danielle, how do you think the manager should proceed with this?
Yeah, it's a great question and real life scenario here. So in our response is that owner agents must enforce the lease to ensure peaceful enjoyment of the premises by other residents. Owner agents should also determine if the actual and imminent threat to other tenants or those employed or providing services to the property. Some of the factors to consider is, again, as we just discussed, duration of the risk, nature and severity of potential harm, likelihood that the potential harm will occur, and again, length of time before the potential harm would occur. So some ideas to reduce and eliminate threat is to evict or terminate only when no other actions are available. Other options: bar the perpetrator from the property where local and state laws permit. Change the victim's locks pursuant to owner agent's lock replacement policy and state and local laws, and encourage victim to seek an emergency transfer, allow an early lease termination, and also help the victim access available services. All right, so here we're going to pause for a few questions, and reminder to send your questions over to Carissa.L.Janice@HUD.gov.
Okay. Danielle, and we do have some other questions that have come in related to your topic. First one, how long does the lease bifurcation process take?
So it can vary by property. We don't have a straight answer for that, but important thing is we want you to follow your federal, state, and local laws for the process.
Okay. And Carissa Janice has joined us. Thank you for joining us, Carissa. And how should, the next question, how should an owner agent respond to repeated VAWA requests from the same household? Carissa, do you want to take that question?
Well, I think that they have to continue to respond to them in the same manner, according to their requirements, and afford them, every opportunity to seek protection and/or transfers.
Okay. Danielle, do you have anything you want to add to that?
No, it's a great answer.
Yes.
Yeah, pretty much just treat every instance like it's the first instance, and every instance should be considered an emergency.
Okay. The next question, when establishing eligibility, why is the tenant granted lesser of 90 calendar days or when lease expires instead of the greater of the two periods? Yeah.
Yep, that's a good question. So with that one, it's statutory requirement that HUD cannot pay subsidy for ineligible folks. So with that being, when we were writing the VAWA final rule, we did want to give some type of a grace period to allow a family, if they are not eligible to live at the site, to give them time to find a housing solution for their next step. So that's when the 90-day came in. And then if your lease expires, we cannot legally renew a lease if you're not qualified. So that's why it's the lesser of.
Okay, thank you.
And thank you. So here, the next topic we're going to discuss is emergency transfers. And before we go to the requirements of the emergency transfer plan, let's talk first by what we mean by an internal and external transfer. So an internal transfer is the relocation of a tenant to another unit at the same property where the tenant may move in without completing application process. When we're talking about emergency transfers, this may not be the best option for a victim, but it is an option that us in multifamily have to offer. For your external emergency transfers is the relocation of a tenant to another property, and he or she must meet the eligibility requirements for the other property and complete the application process. That basically just means that the tenant moves out of your property and moves into another property, and that individual goes from being a tenant at your property to an applicant at another property. It's important for multifamily to clarify the difference between the two because our office is different from, for example, the voucher program. Our families cannot take a voucher and move the assistance to another unit. For multifamily, our assistant stays within the unit. And also, since we're not a public housing program, it's going to be a little more difficult for us to facilitate those moves. And next slide. So now we clarify the difference between an internal and external transfer, and let's talk about the emergency transfer plan. And the VAWA final rule requires owner agents to adopt an emergency transfer plan based on HUD's model transfer plan form 5381. In this model form, it's available on HUD clips. VAWA 2013 requires owner agents to assist victims in making internal and external transfers when possible. Owner agents must adopt emergency transfer plan no later than June 14th, 2017. So if this is news to you, please be sure to get started on your plan as soon as possible because we are now in July. The current model 5381 does not contain all the required criteria as stated in the final rule, so it is very important to note if you are using the model form and decided to implement that, you are going to be needing some more, or needing to add some more criteria. The model contains only general provisions of the emergency transfer plan that applies across the covered HUD, all of covered HUD programs. So again, adoption of this model plan without further information will not be sufficient to meet your responsibility to adopt an emergency transfer plan. You must consult with applicable regulations and program-specific HUD guidance when developing your emergency transfer plan to ensure their plans contain all required elements. And next, we're going to go over the emergency plan contents. So in here, we want you to define eligibility for emergency transfers. And this is when the tenant requests the transfer and either one believes that there is a threat of imminent harm from further violence, or if he/she remains in the same unit, or two, in case of sexual assault, the tenant believes there's a threat of further violence or the sexual assault occurred on the premises during 90 days preceding the date of transfer request. Another thing we want you to do is describe the measure of any preference or priority given to tenants, applicants who qualify for internal and external transfers. Remember to include this preference in your property tenant selection plan. Third element is statement that the VAWA admission preference, if any, don't supersede usual eligibility criteria. And fourth, incorporate strict confidentiality measures. Only employees with authorized access may have access to this information. Do not enter this information into shared databases or disclose information to any other entity or individual. And more tips of this is in section 11 of the HUD housing notice. Another item of the emergency transfer plan we want you to include is a policy for making internal transfers when safe unit is immediately available. A policy for internal transfers when a safe unit is not immediately available. And reasonable efforts an owner agent will take to facilitate external transfers. And that may include arrangements with your HUD housing providers and outreach activities to community service providers. We just went over the outreach and community service providers, and a policy for requesting internal and external transfer at the same time, whether owner agent will accept or require verbal and written transfer request or certification of the victim's status. And you want to specify the required documentation, if any. Other plan requirements, so an owner agent must make the plan available upon request, and when feasible, publicly available. Owner agents keep record of all emergency transfer requests and their outcomes for 3 years or for a period of time as specified in program regulations define immediately available. For example, a vacant unit ready for move-in within a reasonable amount of time. You want to review your internal and external transfer waitlist policies in your tenant selection plan to determine if changes are needed as well. So the eligibility for transfers. The transfer plan must provide that a tenant residing in a subsidized unit under project-based rental assistance and who is a victim of domestic violence, dating violence, sexual assault, or stalking, that qualifies for emergency transfer if the tenant requests the transfer. And it's the same deal as I mentioned earlier, and it's if they request the transfer and either the tenant reasonably believes that there is a threat of imminent harm from further violence if the tenant remains within the same dwelling unit, or in the case of the sexual assault, the tenant believes that there is a threat of the harm for further violence if the tenant remains in the same unit, or the sexual assault occurred within that 90-day period of the transfer request. A request does not guarantee continued assistance for the external transfer to other HUD housing, and the tenant must meet outstanding eligibility or occupancy requirements to be eligible for that transfer. Alrighty, so the owner agent may establish an admission preference for victims of domestic violence, dating violence, sexual assault, or stalking. The owner agent does not need HUD approval to adopt a VAWA preference. This is an acceptable owner adopted preference under 24 CFR 5.655C4. Owner agents must modify their tenant selection plan to include the owner adopted preference, and the tenant selection plan will be reviewed during the property's management and occupancy review. Owner agents may also establish a waitlist priority for internal transfers and will need to amend the tenant selection plan for priorities of the internal transfer waiting list. So Carissa has been helping us field questions. Carissa, did we get a lot of questions come in?
We do. We have a number.
Excellent,
Yes,
excellent.
yes.
And what we did is she was fielding which ones we're going to be announcing today in the presentation. And now that she's here, she will help us answer.
Let me just suggest, though, could you just very briefly mention what we're going to talk about in next week's broadcast?
Absolutely.
So people have an idea if they want to watch that or if this was sufficient for them.
Yep. So today, the purpose of today's broadcast was to do VAWA final rule from the owner agent's perspective. And next week on Tuesday, I believe Marilyn mentioned during her introduction that it will be VAWA final rule, but from the HUD PBCA perspective. So we still encourage our owners to view that webcast. That way, when it is time for your MOR, you're going to be seeing what the enforcement action will be from the HUD PBCA perspective. Thanks for the reminder. And hopefully y'all have been sticking with us this last hour. So we're about 3:40. Let's take a few questions. Alicia?
Okay, we have a question here. Should all VAWA transfer requests be considered an emergency?
Yep.
Carissa, do you want to take
Yeah,
that?
the answer is yes.
Okay, then.
That was easy.
Yes.
Yeah, that was easy. That was easy.
Then, yeah, do you want to add something to that, or?
Yeah, I mean, it's similar to the question that Chris answered before, is that, yes, every instance is an emergency, treated as a matter of life and death. You don't want to be that property owner where there is the next day somebody deceased in your unit. So it is a critical factor, and we want to treat every VAWA protection as an emergency.
Yes. Next question. Once the model transfer plan, HUD form 5381 is updated, will owners and agents need to notify residents of the new 5381?
So that's the emergency transfer plan? Is it?
Yeah, well,
Yeah, okay.
it is. We didn't discuss it being updated. However, the department is in the process of reviewing the forms that are currently out on our website, and that Anicia and Danielle have both discussed. At some point, we will be issuing draft versions of revised forms for people to review. But we should wait on that and really emphasize to you that at this point, we really ought to use the forms as they are on HUD's website right now. And when and if they are revised and updated, we will certainly let everybody know. So I think what I want people to know, because I don't want to cause confusion, is I want people to use the forms that are on our website now. And the most important thing about the emergency transfer plan form, as Danielle mentioned, is that the form itself it is and it always will be just a guide and a model. Well, it's more guide of how to write your emergency transfer plan. So it's really important to use that form, the 5381, but also to make sure that you're using it in conjunction with our multifamily housing program notice and the part of the VAWA regulation that discusses the requirements for the emergency transfer plan.
Thank you, Carissa. And the next question. In facilitating an emergency transfer, how involved should site staff get in ensuring the resident follows through with available resources? Danielle, you want to take that one?
Can you repeat it again? Sorry.
Okay. Okay. All right. In facilitating an emergency transfer, how involved should site staff get in ensuring the resident follows through with available resources?
Yeah, great question. So I know Chris is dying to chime in here. She was our service coordinator expert for several years here, and I'll definitely let you chime in with your expertise. But in your emergency transfer plan as an owner, you want to articulate what resources are going to be available, and those resources you're going to obviously share with the family. You as an owner are not a service provider, so we do not expect you to act like one. You're just really like the referral, trying to get them to the right resources that are available in the public to some extent help facilitate that transfer, but you're by no means the service coordinator of making sure that that transfer happens. Your job as an owner would be to articulate to the family and have them decide if that is a safe available unit.
Yes. Carissa, you want to add to that?
No, I mean, that was pretty much what I was going to say. I was
Yes.
going to say short and sweet. We hope and expect that you will provide contact information for service providers in your area. And if the resident, and it's the resident's choice, as always, as to whether or not they want to contact those service providers. So we ask you at least to do some research, find the current information, contact information for the service providers in your area, and make sure, to the extent you can, that those residents get that contact information. And beyond that, it's really up to the resident to decide what he or she wants to do.
Yes. Thank you, Carissa. Okay.
All right, so I'm going to go over just a few more slides, and we're going to continue taking those questions. So for HUD enforcement, during an on-site management occupancy review and as part of an off-site desk review, HUD or the property's performance-based contract administrator, PBCA, or the property's traditional contract administrator, a TCA, staff will review the owner agent's compliance with the VAWA final rule. And the VAWA claims policies transfer plan will be reviewed as part of the MOR. Reviewers will identify areas of noncompliance of the emergency transfer plan, tenant selection plan, your wait list, internal and external wait list, your preference and priority, record keeping, and keeping your files confidential. For record keeping and reporting, the VAWA final rule does require owner agents to keep confidential records of all emergency transfers requested under its emergency transfer plan and the outcomes of such request, and to retain these records for a period of 3 years, or for a period as specified in program regulations. The VAWA final rule further requires that these requests and outcomes should be reported to HUD annually, and HUD plans to add these data elements in a future release of tracks. And we have coordinated with the tracks team here at headquarters to see what funding will need to be available and to see if that is the best option for us. In the big picture, we want this to be an automated process and not a manual process, so in the notice we did give you some leeway with that. And for fair housing and non-discrimination, owner agents must comply with applicable fair housing and civil rights laws and requirements in the implementation of VAWA requirements. This includes, but is not limited to, Fair Housing Act, Title IV of the Civil Rights Act, Section 504 of the Rehabilitation Act, and Americans with Disabilities Act. Examples include you would provide reasonable accommodations for persons with disabilities to VAWA protections and procedures, and you would ensure access to and accessible versions of VAWA documents to LEP individuals and people with disabilities. And I think here we will take in more questions that came in. If we can have the slides here for the questions. Alrighty.
Let me just interject. You mentioned providing opportunities for LEP individuals. Those are people with limited English proficiency.
Yes, thank you.
Thank you for clarifying that.
It's easy to get stuck in all the acronyms at HUD. Okay, so first question, another question here. Is the lease term of the newly signed executed lease for the individuals, I'm going to start over. Okay, is the lease term of the newly signed / executed lease for the eligible remaining members the remaining term of the prior lease or a new one-year lease?
This is in the case of the lease bifurcation.
Okay. Do you want to answer it? Yes. You don't? I'm a little confused. But okay, so if you could break down the question here. So what were you saying, Krista?
So okay,
Lease bifurcation?
so if when you bifurcate a lease and you're providing the remaining family member or household member a new lease. So is that the new lease that you're providing that household member? Does that follow the term of the last lease that you just bifurcated, or are you giving them a new one-year lease?
Great question. My initial answer would be it's a brand new lease.
Yes.
Do you agree?
I agree with that 100%, yes.
All right.
So
well,
a brand new lease would mean a 12-month term?
yes,
Yes.
you're starting up a new initial lease.
Okay.
Okay, so, but if we are accepting an internal, I'm sorry, if we are accepting, okay, you're reading the next question. 'Cause- okay, but if we are accepting an external emergency transfer and that applicant is placed at the top of the wait list, how are we to document for HUD or the state financing agency that we appropriately took an applicant out of the order of the wait list and placed him or her in the property as an emergency transfer? Okay, so if I'm reading the question right, it sounds like you're owner B and maybe owner A is calling you saying that they want you to accept this person, and jump them on the wait list. So if I'm reading the question right, owner B pretty much has the preference and the ability to implement the preference. So HUD, your VAWA preference is not a HUD mandated federal preference. So HUD cannot force you as an owner to have a preference. In the spirit of the program, it is best interest and the most smoothest way to facilitate these transfers. So if you do decide to adopt a VAWA preference, then in your tenant selection plan, you as the owner get to decide the priority of any other preferences you have on your property and work it that way. So the owner A cannot tell you the order of accepting this applicant. You as your owner of your property would decide that and articulate it in your tenant selection plan. What do y'all think?
What do you think, Chris?
Yeah. So really, the only way that you can move a person who has requested VAWA protections and an emergency transfer, the only way you can put them at the top of your list if you have a pre-existing preference in your tenant selection plan for victims of domestic violence, dating violence, sexual assault, or stalking. If you don't currently have that preference in your tenant selection plan, then any individual coming to or wanting to move into your property would have to go to the bottom of the waiting list. So that's why Danielle said for future purposes, we would encourage owners to put a preference in their tenant selection plan, but it is totally at the option of the owner to decide whether they want to do that or not.
Yes.
Okay.
The next question, how should we add the new VAWA requirements to the tenant selection plan?
So if you as an owner decide to adopt a VAWA preference, then you would add it to your tenant selection plan. I don't recall off the top of my head, but there is some, do you have to notify current residents of change it to TSP?
I would imagine so.
I'm not sure, because you're
Really?
saying your audience is given to the applicant, so you're disclosing this to applicants. You do have to notify them for house rules. But good thing the HUD handbook is out there, because you can look at the HUD handbook 4350.3, and that's exactly what I would do if I was in my office right now. But yeah, so just you can update your tenant selection plan to add in that preference.
But I think part of the question, though, might be other policies, other things that you've discussed, like whether somebody can, in order to request a VAWA protection, request VAWA protections, whether they can make a verbal request or statement, or whether they have to submit some sort of documentation, or what would you do in the case of the adverse factors that you recently discussed? Do those type of policies need to be in the tenant selection plan? And from what we've discussed, my understanding is that the only policies that need to be in the tenant selection plan are those that relate to the waiting list and the actual selection of potential tenants. So while we highly encourage you to have written VAWA policies for a number of the other items that we discussed, those wouldn't go into the tenant selection plan per se. They would be elsewhere in your written policies.
Great.
Okay.
Thanks.
Thank you. Next questions.
I think that was the same as the last one. Our owner agent's required to have a separate VAWA policy, so Krista covered that.
You answered that.
Yeah.
Go ahead.
Okay. Are these recommendations, and I believe this is the, so are these recommendations or requirements for rural development properties, specifically all forms and et cetera?
Yeah, it's a good question. We see a lot of our Section 8 properties layered with tax credit, rural housing 515-8s. But this presentation and even the VAWA notice, our VAWA final rule is specific to HUD-assisted properties. Our VAWA notice is specific to our 228s and PRACs and PACs. So we would recommend you to contact your rural development and see how they are implementing the VAWA final rule for their units.
We should add, though, that if you have a rural, you live in a rural housing service property that has a Section 8 contract, then these requirements do apply. So all of these requirements apply to properties with HUD project-based Section 8. So again, if you're a rural housing project with a project-based Section 8 contract, then yes, you need to conform to all of these requirements. If you're a rural housing project with rural housing rental subsidy, then as Danielle said, please check with the rural housing service.
Yes. Thank you.
Okay.
Yes.
And I believe that was the last real audience question, unless there's more on the script, if the slide flips. All right, one more here. It's a big one. You want to read it?
Yes, it is a big one. We plan to do a mass VAWA lease signing in our PRAC buildings. What start and end date should we use on the lease? The goal is to get these signed before the deadline date of December 15th. And most of the residents have already been recertified for 2017. So
I can take that one.
Okay.
Yeah,
Good.
I can take that one. So Anicia covered earlier the VAWA lease addendum, and it sounds like this is what that question's referring to. So the current VAWA lease addendum is specific to Section 8 only, because previously the VAWA final rule was only applicable to Section 8 properties. VAWA 2013 expands it to our 202 PRACs, and so since we are currently in the process of updating the Section 8 lease addendum, the 91067 form. And so if you're a PRAC property, we highly recommend not to quite implement this lease addendum quite yet, because the one on the streets is your Section 8 one. Once we work through the Paperwork Reduction Act and getting that form updated, which we have sent over, and it should hopefully get published in the Federal Register for comment. But long story short, just hold off implementing the lease addendum until we get the new revised and refreshed one out to the public.
Yes, and to add to that, Danielle, the owner agent wants to keep in mind that by signing the lease addendum, this VAWA lease addendum, they're actually changing the lease. So there are requirements as far as tenant notification prior to actually signing that. I believe it's 60-day notice, and I believe it was paragraph 6-12, I believe it was. Okay. And just make sure that, so I don't think, unless you have a mass recertification date.
Schedule, yeah.
Yeah, mm-hmm. So I don't think that you would be able to do a mass lease signing of the VAWA addendum.
Right, good
okay?
point. Yeah, thank you.
Also, the dates that the person mentioned, those dates are more significant for the distribution of the notice of occupancy rights and the certification form. So I guess what we really want to emphasize is when our Form 91067 VAWA lease addendum has been modified and is ready for use, then people should start using it at that point. So meeting this December deadline with the VAWA lease addendum is not essential. It is more essential for the notice of occupancy rights.
Right.
Yes. Mm-hmm. Thank you.
Good point.
Yes. Okay.
Any more questions?
So I have a
Yep.
question that that's come in that I thought might be helpful, because I'm not sure if we really address that here. One of the forms that you mentioned was the emergency transfer request form. The number is 5383. And so people are a little unsure about how they're supposed to use that form.
And you want to take that?
You can take it.
Oh, my goodness.
And if not, I'll see what I can think of.
Yeah, and what is the title of that form?
Oh,
It's the
it's the last
emergency
one.
transfer
Yeah,
request form.
Okay,
It's basically a form where that you can facilitate the documentation. So a resident would say, I'm asking for VAWA protections, and you as the owner, you can give them that form to fill out to help facilitate the transfer here.
Right, well, this form, it's specifically to request an emergency transfer.
Right.
So, again, it's a model form. You can give it, property management staff can give it to their residents if they want to request an emergency transfer. It's all ready to go. So you don't have to do any work. You can just give it to them and they can use it. If you want, you could modify it. You could use the contents of it and make your own form. But we're just aiding you all or assisting you all by providing you with this form that would be easy to use. The form also does include other types of documentation that could be provided, I believe, in terms of, I guess there's the other types of documentation, just again to certify that you're a victim. So it's just helpful for people, it's easy to use, and that's why it's out there.
Yeah, and we hope that y'all are using it. So we have about 4 or 5 more minutes. Any more questions come in? I think we are in the clear, and it's perfect timing. So I just thank you, Carissa, for joining us and helping us out with the live Q&A here. And thank you, everyone, for joining us. We will have part 2 of the VAWA presentation from PBCA HUD perspective on Tuesday.
Yes.
So we hope you tune in, and feel free to give us an email or give us a call or shoot us an email if you have any other questions. Thank you and have a great day.
Thank you.
Thanks.